Okay, in U.S. v. Robinson, Justice Rehnquist delivered the opinion of the court in 1973. Respondent Robinson was convicted in the United States District Court for the District of Columbia of the possession and facilitation of concealment of heroin. The Court of Appeals Bank reversed the judgment of conviction, holding that the heroin introduced in evidence against respondent had been obtained as a result of a search warrant which violated the Fourth Amendment to the United States Constitution. On April 23, 1968, at approximately 11 o'clock p.m., the officer Richard Jenks, a 15-year-old veteran of the District of Columbia Metropolitan Police Department, observed that respondent driving a 1965 Cadillac near the intersection of 8th and C Street Southwest in the District of Columbia. Jenks, as a result of previous investigation, following a check of respondent's operator's permit 4 days earlier, determined there was reason to believe that respondent was operating a motor vehicle after the revocation of his operator's permit. This is an offense defined by statute in the District of Columbia, which carries a mandatory minimum jail term, a mandatory minimum fine, or both. Jenks signaled respondent to stop an automobile, which respondent did, and all three of the occupants emerged from the car. At that point, Jenks informed respondent that he was under arrest for operating after revocation and obtaining a permit by misrepresentation. It was assumed by the majority of the Court of Appeals and is conceded by the respondent here that Jenks had probable cause to arrest respondent and that he effected a full custody arrest. In accordance with procedures prescribed in police department instructions, Jenks then began to search respondent. He explained at a subsequent hearing that he was face-to-face with the respondent and placed his hands on the respondent, my right hand to his left breast like this, demonstrating, and proceeded to pat him down thus with the right hand. During this pat-down, Jenks felt an object in the left breast pocket of the heavy coat respondent was wearing, but testified that he couldn't tell what it was, and so that he couldn't actually tell the size of it. Jenks then reached into the pocket and pulled out the object, which turned out to be a crumbled up cigarette package. Jenks testified that at this point he still did not know what was in the package. As I felt the package, I could feel objects in the package, but I couldn't tell what they were. I knew they weren't cigarettes. The officer then opened the cigarette pack, and found 14 gelatin capsules of white powder, which he thought to be, and which later analysis would prove to be heroin. Jenks then continued his search of respondent to completion, feeling around his waist and trouser legs and examining the remaining pockets. The heroin seized from the respondent was admitted into evidence at the trial, which resulted in the conviction in the district court. It is well settled that a search incident to a lawful arrest is a traditional exception to the warrant requirement of the Fourth Amendment. This general exception has historically been formulated into two distinct propositions. The first is that a search may be made of the person of the arrestee by virtue of the lawful arrest. The second is that a search may be made of the area within the control of the arrestee. Examination of the court's decisions in the area show that these two propositions have been treated quite differently. The validity of the search of the person incident to the arrest has been regarded as settled from its first enunciation and has remained virtually unchanged until the present case. The validity of the second proposition, while likewise conceded in principle, has been subject to differing interpretations as the extent of the area which may be searched. So the second proposition is that search may be made of the area within the control of the arrestee. So, the footnotes here I'm just going to read what's highlighted. Those regulations also provide that in the case of some traffic offenses, including the crime of operating a motor vehicle after revocation of an operator's permit, the officer shall make a summary arrest of the violator and take the violator in custody to the station house for booking. Okay, so this is testimony. It just was omitted from the case, I think. But Terry Ohio versus Ohio is the footnote on the next page. So the reference to Terry v. Ohio relied upon here by the Court of Appeals, where the Supreme Court held that on reasonable suspicion, that is individualized suspicion short of the probable cause needed for an arrest, the police may stop a person for investigation. The court also held that incident to such a stop, the police may take limited steps for their own protection. A full incident to arrest type search of the person not permitted, but upon reasonable suspicion that the person is armed and dangerous, the officer may pat him down and reach into his pockets upon feeling something that could be a weapon. So, going back to the present case, throughout the series of cases in which the court has addressed the second proposition relating to a search incident to a lawful arrest, the permissible area beyond the arrestee, which such a search may cover, no doubt has been expressed as to the unqualified authority of the arresting authority to search the person of the arrestee. Thus, the broadly stated rule and the reasons for it have been repeatedly affirmed in the decisions of this court since Weeks versus United States nearly 60 years ago, since the statements in the case speak not simply to terms of an exception to the warrant requirement, but in terms of an affirmative authority to search. They clearly imply that such searches also meet the Fourth Amendment requirement of reasonableness. Virtually all of the statements of this court affirming the existence of an unqualified authority to search incident to a lawful arrest are dicta. We would not therefore be foreclosed by principles of stare decisis from further examination into history and practice in order to see whether the sort of qualifications imposed by the Court of Appeals is in this case were in fact intended by the framers of the Fourth Amendment or recognized in cases decided prior to Weeks. Unfortunately, such authorities as exist are sparse. While these earlier authorities are sketchy, they tend to support the broad statement of the authority to search incident to arrest found in the successive decisions of this court, rather than the restrictive one which was applied by the Court of Appeals in this case. The justification or reason for the authority to search incident to a lawful arrest rests quite as much on the need to disarm the suspect in order to take him into custody as it does on the need to preserve evidence on his person for later use at trial. The standards traditionally governing a search incident to lawful arrest are not, therefore, commuted to the stricter Terry standards by the absence of probable fruits of further evidence of the particular crime for which the arrest is made. Nor are we inclined on the basis of what seems to us to be a rather speculative judgment to qualify the breadth of the general authority to search incident to a lawful custodial arrest on the assumption that persons arrested for the offense of driving while their license has been revoked are less likely to be possessed of dangerous weapons than are those arrested for other crimes. It is scarcely open to doubt that the danger of an officer to an officer is far greater in the case of the extended exposure which follows the taking of a suspect into custody and transporting him to the police station than in the case of relatively fleeting contact resulting from the typical Terry-type stop. This is an adequate basis for treating all custodial arrests alike for the purposes of justification. So this is another legitimate state interest in police officer safety justifies the search. But Quite apart from these distinctions, our more fundamental disagreement with the Court of Appeals arises from the suggestion that there must be litigated in each case the issue of whether or not there was present one of the reasons supporting the authority for a search of the person incident to a lawful arrest. We do not think the long line of authorities of this court dating back to Weeks, nor what we can glean from the history or practice in this country and in England, requires such a case by adjudication. A police officer's determination as to how and where to search a person of a suspect whom he has arrested is in a lawful arrest, is necessarily a quick ad hoc judgment which the Fourth Amendment does not require to be broken down in each instance into an analysis of each step in the search. The authority to search the person incident to lawful custodial arrest, while based upon the need to disarm and discover evidence, does not depend on what the country or the court may later decide as the probability of a particular arrest situation that weapons or evidence would be found. In fact, be found upon the person of the suspect. A custodial arrest of a suspect based on probable cause is a reasonable intrusion under the Fourth Amendment. That intrusion being lawful to a search incident to the arrest requires no additional justification. It is the fact of the lawful arrest which establishes the authority to search, and we hold that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also reasonable under that amendment. And I'm going to name the cases here in the footnotes. On the next two pages, there's very many. There's Schmerber, Schmerber versus California of 1966. The court held that intrusions into the human body ordinarily require a warrant, but acknowledged that often exigent circumstances would excuse a warrant before taking a blood sample to determine DUI suspect's blood alcohol content. Missouri versus McNeely, the court granted cert to resolve a split authority on the question whether natural dissipation of alcohol in the bloodstream establishes a per se exigency that suffices on its own to justify an exception to the warrant requirement for non-consensual blood testing and drunk driving investigations. Now, how did they answer that? The majority, per Sotomayor, acknowledged that because an individual's alcohol level gradually declines soon after he stops drinking, a significant delay in testing will negatively affect the probative value of the results, but asserted does not follow that we should depart from careful case-by-case assessment of exigency and adopt the categorical rule proposed by the state. And in Amici, in those drunk driving investigations where police officers can reasonably obtain a warrant before a blood sample can be drawn without significantly undermining the efficacy of the search, the Fourth Amendment mandates that they do so. Blood testing, the majority asserted, is different in critical respects from other destruction of evidence cases, as the evidence naturally dissipates over time in a gradual and relatively predictable manner, and some delay is inevitable in any event because the police officer must typically transport a drunk driving suspect to a medical facility and obtain more assistance of someone with appropriate medical training before conducting a blood test. Moreover, 47 years since Schmerber was decided as the federal rules of criminal procedure, and well over a majority of states allow police officers or prosecutors to apply search warrants remotely through various means, through telephonic or radio communication, electronic communications, as well as all this, video conferencing, etc. So the majority of states are getting the search warrant electronically. So So that's that. They didn't really tell us the holding, but it sounds like a search warrant for blood testing might have been the outcome. Oh, the majority asserted that. Okay. The majority requires warrant. For blood alcohol content. Okay. Roberts, for 3 justices dissenting, had something else to say. So, the case of Cup versus Murphy comes in, where there is a warrantless search of a person without any contemporaneous arrest. And the court held that where Murphy voluntarily appeared at the station for questioning concerning the strangulation of his wife, at which time the police noticed what appeared to be blood on his finger, the police had probable cause to arrest him, but did not formally place him under arrest. The warrantless taking of scrapings from his fingernails was constitutionally permissible. Noting that Murphy was aware of the police suspicion and tried to wipe his fingers clean, the court concluded that rationale underlying the search incident to arrest doctrine justified the police in subjecting him to a limited search necessary to preserve the highly evanescent evidence they found under his fingernails, but because a person not under formal arrest might well be hostile to the police and less likely to be conspicuous, immediate steps to destroy incriminating evidence on this person, the court emphasized it was not holding that a full search would have been justified in this case without a formal arrest, without a warrant. So it was not holding that. Concurring noted that the police could not have preserved any evidence by close surveillance and that detaining Murphy while a warrant was sought would have been as much a seizure as detaining him while his fingernails were scraped. Dissenting argued that there was time to get a warrant. Murphy could have been detained the whole time. So I'm going to skip again to Rawlings versus Kentucky now in 1980, where a formal arrest quickly followed on the heels of the challenge search of a petitioner's person. We do not believe it particularly important that the search preceded the arrest rather than vice versa. Wow. It seems elementary. Consider also Illinois versus Lafayette, 1983, concerning the basis for arrest upon the arrestee's arrival at the place of detention. The governmental interest underlying a station house search of the arrestee's person and possessions may, in some circumstances, be even greater than those supporting a search immediately following the arrest. Consequently, the scope of a station house search will often vary from that made at the time of arrest. Police conduct that would be impractical or unreasonable or embarrassingly intrusive on the street can more readily or privately be performed at the station. For example, the interest supporting a search incident to arrest could hardly justify disrobing an arrestee on the street, but the practical necessities of routine jail administration may even justify taking a prisoner's clothes before confining him, although this step would be rare. At the station house, and it talks about proper protocol of inventory search. So there's only about a paragraph left of the present case before us. So again, they were just getting into the holding. We hold that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under the amendment. The search of respondent's person conducted by Officer Jenks in this case and the seizure from him of the heroin were permissible under established Fourth Amendment law. Since it is the fact of custodial arrest which gives rise to the authority to search, it is of no moment that Jenks did not indicate any subjective fear of the respondent or that he did not himself suspect the respondent was armed. Having, in the course of lawful search, come upon the crumpled package of cigarettes, he was entitled to inspect it, and when his inspection revealed the heroin capsules, he was entitled to seize them as fruits, instrumentalities, or contrabands, probative of criminal conduct. The judgment of the Court of Appeals holding otherwise is reversed. And so then we enter into the dissenting opinion of 4 pages. It talks about Terry a lot. I'm at 20 pages, so I'm just going to read that to myself.